Minority Leader case Ato Forson and Attorney General Godfrey Dame have been enjoying each other's company in court. What is it about? Have a look at this video of ambulances lined up at the Independence Square on the morning of the commissioning of the ambulances by President Akufo-Addo. It was after the commissioning that we had been told that the story of the ambulances is not a simple story. It's a long story, and one day we'll understand. These are the ambulances that were delivered by my personal favorite lady, Hawa Kumsin, who was at that time President Representative of Special Initiatives. These are the ambulances. They were about 300. Each constituency, political constituency, got one, 275 of those. And then the rest were distributed among hospitals and other places and outside Accra and all of that. These are the ambulances that the Ghanaian people are now benefiting from across the whole country in all constituencies. This is the subject matter of a court trial, a criminal trial process that is being held in Accra over the ambulances that have finally been delivered. We'll come back to the ambulance video in a while. But here is the story. The Republic versus Kesel Ato Forson. Okay, so what has happened is that, as we do know of criminal processes, the Attorney General has built his case against the Minority Leader. At the end of the Attorney General's case, the Minority Leader and his lawyers elected to use the process of submission of no case. So they are telling the court that we have heard the Attorney General. He didn't say anything that's incriminating. He has not been able to make a prima facie case for us to answer. And they invited the court to evaluate that and make a decision. The court made a decision that no, Mr. Minority Leader, you're wrong. The Attorney General has made a case for you to answer. The whole matter hinged on a testimony by my friend, the Honorable Sir Tekpe. Now, Sir Tekpe rendered a testimony in the trial. And in that testimony, the court concluded that Mr. Tekpe was not able to completely convince the court that he was responsible for something that the prosecution, that the accused people believed that he should have been responsible for. Let's get on to the script now. All right. The facts of the matter are as follows. The then Deputy Minister of Finance, Mr. Ato Forson, is believed to have granted authorization to the Ministry of Finance to release money to the sum of 2.37 million euro for the purchase of certain vehicles. Even though parliamentary agreement stipulated them to be ambulances, the vehicles arrived only to be trucks and not fit for purpose. Following the argument of the Attorney General, Mr. Forson, through his lawyers, argued that the Attorney General has not established a prima facie case and therefore the court should throw out the matter. Okay, this is the case of the Attorney General. One, he says, Ato Forson's approval letter led to causing financial loss to the states. Now, why does he say that? He told the court that the approval letter that was written by Mr. Ato Forson. So what happened? The parliament in the Mills Parliament had discussed these ambulance matters. And then the new government had come. There's a conversation between the Deputy Attorney General Godfrey Dominicayini and Madam Sheriaite, who was Minister of Health, which is very instructive in the whole matter. If you see what Sheriaite said she will not do, even though the Deputy Attorney General was urging her to do, then you see what other people did. It might make you think one way or the other, but there's a matter still on trial. So we have to talk about it as if it is still on trial. All right. Ato Forson's approval letter led to causing financial loss to the state, isn't it? Okay. The Attorney General argues that by a letter dated 7th August 2014, signed by Dr. Ato Forson, the Bank of Ghana was urgently instructed to establish an irrevocable, transferable letter of credit, LC, in the sum of 3.950 in favor of Big C General Trading, LLC, as payment for the ambulances to the Ministry of Health. Alrighty, let's go on. His authorization for the LCs to be established resulted in the payment of 2.37 euro for the supply of vehicles by Big C General Trading Company Limited, which did not meet the description of an ambulance. A fact clearly established from the evidence on record, Attorney General says. His actions were criminally negligent and most unwarranted. Okay. That Mr. Ato Forson did not seek any authorization before ordering the payment. The Attorney General further submitted that the first accused omission to respect the terms of the agreement between the parties showed the willful the willfully causing financial loss to the Republic. I can see this well. But he's saying that the omissions of Mr. Ato Forson indicated a financial loss to the Republic. Okay. Quote, he says, it can clearly be deduced that he desired to cause financial loss. He, Ato Forson, desired to cause financial loss. Or he foresaw the loss as virtually certain, but took an unjustifiable risk of it. Or he could foresee the loss as probable consequence, but elected to unreasonably risk same. Or he failed to exercise due care and attention and thereby caused a loss. These are the points that the Attorney General made. That he either did this, he did that, he did that, he did that. I like the last one. He says, or that he failed to exercise due care and attention, and therefore he caused loss to the state. I like the last one. Okay, let's move on. The Attorney General further submitted that the first accused did his actions without any further authorization from any quarters. A careful examination of the record does not disclose any so-called authorization by the former Minister for Finance or indeed any superior officer. On the contrary, exhibit tendered by the prosecution showed that Dr. Ato Forson acted on his own and not through any alleged authorization by his former boss, Mr. Seth Tekpe. All right. That the state suffered a loss. Now, Mr. Dami was demonstrating that the state actually did suffer a loss. Let's see what he says. He says, when the vehicles arrived, they were not fit for purpose. Letters written by Dr. Alex Segbefia, former Minister for Health, indicated categorically that the vehicles were ordinary vans and not ambulances. These letters, written by Dr. Alex Segbefia, were tendered in without objection by the counsel for the defense. This is quite interesting, isn't it? It requires some commentary. The report is saying that part of the evidence that the Attorney General has built against Mr. Ato Forson is emanating, can you imagine, emanating from Alexander Segbefia, who became health minister just before election 2020. That Mr. Segbefia wrote something which is now being used to build a case against Ato Forson. That's quite interesting, isn't it? Okay, let's move on. Evidence of reckless spending. It's as follows. The prosecution further stated that assuming without admitting that the first accused was justified in considering the contract as effective, the action of the former Minister of Health, Madam Sheriaite, when she was called upon to perform the contract, exposed the recklessness of the first accused. In reaction to the advice of Dr. Dominic Ayini, former Deputy Attorney General, that the contract had become effective and therefore had to be performed, Madam Sheriaite, exercising proper care and caution, indicated to the former Deputy Attorney General that the Stanbic facility required for the performance of the contract had not been secured, and therefore her ministry did not have the budgetary provision for the contract. Again, this is also quite worrying, particularly worrying. This is describing the Minister for Health under the same administration, the same government, sitting in the same cabinet, who was directed by the Deputy Attorney General to issue payments for these same ambulances that didn't come, they came, they are not fit for purpose, something like that. Yeah. So she said she will not be able to do that because the budgetary allocation has not been made for it. And therefore she cannot issue letters of credit. That's what Sheriaite said. Then Alex Segbefia said the thing came, it wasn't good. These are the materials that the Attorney General is holding against the minority leader. It's not nice. However, in complete contrast and in a manner consistent with recklessness, first accused on 7th August 2014 instructed the governor of the Bank of Ghana to urgently establish the LCs for the supply of the ambulances. Quote, while arrangements are being made to perfect and sign the loan agreement. Oh, I see. He said he should organize the money while arrangements are being made to sign the loan agreement. Okay. Be that as it may, first accused never followed through with any arrangement to perfect and sign the loan agreement, unquote, after directing that payment should be made from the Ministry of Health's account. Wow. She said in a statement taken from the then former Finance Minister, Seth Tekpe, was not conclusive as to whether or not he gave Dr. Ato Forson authority to have the LCs established. That's also quite interesting. Justice Adom-Otchere explained that in a criminal case, it is the duty of the person making a positive averment to show proof thereof. and not the party making a negative averment. This ruling appears to pave the way for Tepe to be called as a witness for Dr. Forson if the defense so wishes. This is also quite worrying. The defense was given up to April 11th, 2023 to file a witness statement and indicate who those witnesses are. So the Tepe has also been part of the trial process, where the trial judge is now saying that, having listened to the evidence of Mr. Tepe, she is not convinced, and that the court is not convinced that Mr. Tepe is saying that he actually gave authorization. That's also very worrying. Your boss, the former minister, has come to court and is asked, did you give authorization? I was in the court. I know whether he said yes, no, it may be so, I don't know. But the judge is reporting that whatever Mr. Tepe said did not convince the court that it was he who gave the instructions, as I'm sure the defense counsel was hoping for. That's a serious matter.